Hey, everybody, welcome back to SEC Roundup. I'm Nick Morgan, the co-founder of ICAN, Investor Choice Advocates Network, and the co-host of today's episode of SEC Roundup, joined by our sometime co-host, Jennifer Schulp. Jennifer is the Director of Financial Regulation Studies at Cato. Jennifer, thank you for joining.
Glad to be here.
And our special guest today is Chris Iacovella, who is the CEO of American Securities Association. Chris, you've been on the program a couple of times before. Thanks for coming back.
Yes, it's a pleasure. It's always great to be here.
So the reason we're getting together today is a pretty blockbuster ruling out of the 11th Circuit last Friday, or at least blockbuster to people like the three of us. And hopefully, as people understand more about it, they'll grow to appreciate it as well. But the ruling had to do with a very large database mandated by the SEC called the Consolidated Audit Trail database, or CAT. And since most people haven't heard of the CAT, Jennifer, and I know you have been studying it closely, you allowed us to join your amicus brief in support of the lawsuit by Chris's organization and Citadel that gave rise to Friday's ruling. So maybe you could just give us a little backgrounder on the CAT and why it's, or some of the reasons it's problematic. And we don't have time to cover all of them, so just maybe hit the highlights.
I was happy to do that. And we have to kind of go a ways back to start talking about the Consolidated Audit Trail. It all started with the flash crash in 2010. And at that time, the SEC was having a hard time figuring out what had happened during the flash crash. And it placed the blame on the fact that trading data was fragmented. Not exactly clear that that would have made a huge difference ultimately in figuring out the flash crash, but of course, good ideas never die. So the SEC moved on to this idea of a, quote, Consolidated Audit Trail, or the CAT. In 2012, the SEC adopted a rule that required the National Securities Exchanges and FINRA to develop, implement, and maintain a consolidated audit trail. And just in terms of layman's terms, that basically means all of the information about a trade should be in one place that's accessible to the regulators. This 2012 rule is something that I think we're going to get back to when Chris talks a little bit more. And it's important here to note that the SEC mandated that CAT was developed, not Congress. So that's a flag for one issue up front. The CAT was meant to contain kind of comprehensive audit trail information for all equities and options trading in the U.S., including information that would connect the trade to the individual who made it. And starting in 2012, there was a pretty long saga of getting the CAT up and running. A lot of details, the administrator had to be changed, it was really hard to put together, and the CAT has just grown substantially in cost since it was first envisioned in 2012. That's also something that we'll get to later in terms of where the problems are. And there are also serious questions about whether the data that the CAT collects could ever truly be considered secure. In 2012, it was kind of a pie-in-the-sky idea. But as we've seen the government get hacked time and time and time again, the SEC has not been immune to that. It seems pretty clear that the data that the CAT collects is just another database that is open to hackers. So separate and apart from the mechanics of the CAT, is it too expensive? Is it collecting too much information? Is it secure? The CAT itself is really a sort of law school issue spotter exam of problems. Can the SEC put something like the CAT into effect without congressional approval? In fact, when taxpayers are ultimately the ones that are going to be paying for this in terms of their trading, is that something the SEC can actually do? Did the SEC act within its authorities when it decided to split the very substantial costs for the CAT among self-regulatory organizations and broker-dealers, and allowing the SROs to pass their costs on to the broker-dealers? And it's the surveillance of the CAT consistent with the Constitution. And that is one of the places that I've been the most focused on. The privacy implications of the CAT are what caused, as Nick said, Cato to file a brief along with ICAN, focusing on the government's intrusion here of knowing everyone's trading information. It's not just a problem of economics, what stocks we buy, telling the government when we make those trades. But what stocks we buy and when can say a lot about who we are as a person, our values, our beliefs, our expectations for the future. And investing itself has become even more politicized. ESG, anyone? The potential for government abuse here rises when the government has a giant database that knows every single stock trade and who made them. The court didn't get to this question, but fortunately the SEC has already gone back to the drawing board about certain aspects of its collection of personally identifiable information, and that's a step in the right direction, but the commission needs to go further. And in many ways, back to the drawing board is a theme from the 11th Circuit opinion in Chris's Litigation. So I'm happy to hand it over to him to let him talk some more about what happened and what's in store.
Yeah. Thanks, Jennifer. That's a great backgrounder. So, Chris, tell us about the lawsuit that ASA and Citadel filed. You were able to go directly to an appellate court because you were challenging a rule, a recent rule from the prior administration's SEC. So maybe give us some background about the case and then tell us what happened on Friday out of the 11th Circuit.
So what happened in the case was there was the funding model, as Jennifer articulated, and what we argued in that the funding model was not fair in the way that the costs were allocated. And so we brought up the challenge directly to the funding model, that the costs weren't fair, they weren't equitable, they weren't reasonable as they're supposed to be pursuant to the statutory direction that Congress gave all of the SEC and the previous commissions to actually expand upon when they were creating this CAT. And then in addition to that piece, we brought up claims that this was a major question, that Congress needed to opine to create such a database because the cost and the size of it in the billions of dollars actually had a direct impact on the economy, on the financial system, and on every user of the U.S. national market system and our equity capital markets. And then we also said that the SEC didn't have the statutory authority to even create the CAT in the first place. What the court decided was, unequivocally and unanimously 3-0, was that we had full authority to challenge the funding model and that the SEC wrongly introduced the split that it did, which ended up being close to 80% towards broker dealers and 20% towards exchanges. And it said that the SEC acted arbitrary and capriciously related to its economic analysis using old data and in the way that it allocated the funding model. And so what it did at the end of its decision, and there's a lot of good law in there, it said that its internal processes were not valid as it related to the way that it constructed the rule and it went about complying with the APA, which is very important for any lawyers who are watching or are thinking of challenging a case in the 11th Circuit, because that draws some very clear distinctions about processes and procedures that must be followed in order for the APA to be complied with during a rulemaking process. So where we are now is 3-0 vote to strike down the funding model, remand it back to the SEC, give them 60 days with which to try to figure out a new funding model, which seems ambitious. And so, I think that's where we are at this moment. So what we're trying to do is turn the page and look at this more holistically, as Jennifer kind of pointed out, which is, should this exist? Okay, what happens to the outlays, the monetary outlays that have occurred up to this point to create the database? Is it right that the SEC even is able to create a rule that demands that regulated entities take a portion of their budget and fund a technology spend? I think that's a critical question. And in any case, the people who were forced to spend based upon a rule probably need to be made whole here. And that's going to require the SEC going to Congress and asking for an appropriation.
Interesting.
So if you have that happening, then the next question is, do you need this database? What's the scope of the database if you do need it? And certainly, there is no reason why this database needs to collect the personal and financial information of every American investor. There is a way for this database to work collecting only the firm level identifier that would track a particular stock and all of the trading in that stock. And then if they see an abnormality in trading that could look like insider trading, could look like market manipulation, they contact the broker dealer and all the broker dealers whose firms were associated with trading that day, and they ask for the customer accounts. And then we give them to them the way we do today in the blue sheet process. That to us is more reasonable because there is actually a reasonable suspicion that a regulatory infraction has occurred in a violation, as opposed to just carte blanche. We're going to collect all the information, then if we'll decide if we find a crime later. And so, I mean, there are some very threshold questions. There are many in the industry who don't want the cat to exist at all because the cost of it is going to continue to proliferate, especially if they want to keep information for 6 years and run the batch data on a daily basis, which we don't see any need for. It doesn't need to be run on a daily basis. It needs to be run when there's a reasonable suspicion that fraud or manipulation has occurred. And so, there is a need, I would say, for a way for the SEC to knit together all of the trading within dark pools and the exchanges together so that it has a global surveillance view of how stock trading occurs. It doesn't need personal information to do that. And it can do what it does today when it needs to catch a violation, as I said, with the blue sheets. But I think there's also a broader interplay here between FINRA and the exchanges, because FINRA is trying to take over and dominate the surveillance and enforcement pieces of this, which is generally left to each individual market. They're supposed to surveil and protect the integrity of their marketplace, and they want to do that. Well, the cat is being used by FINRA and the SEC to some extent to try to push them off of that obligation and insert themselves into that situation so that they could be the only regulators who have insight here. And then you have a foreign actor in FINRA policing the markets of New York and NASDAQ. And I think that that's an issue that they're going to have to deal with, but it's also another issue that we could think of here. And I'd be remiss before I turn it over, is that there is a case in the Fifth Circuit that goes right at the heart of, is this constitutional? Is it a major question? Is there statutory authority to create this? And should investors have all of their information be available in a government registry for the SEC to pick and choose through as they wish?
Yeah, and maybe that's a good launch point for me to ask a follow-up question, which is the suit you're referring to was brought by the New Civil Liberties Alliance. And as you said, as a result of your victory in the 11th Circuit, the ball is back in the SEC's court. I suppose one question is, will the SEC, given that it's going back to the drawing board, be as enthusiastic about defending against that Fifth Circuit litigation as it has been in the past? Any thoughts or speculation on that from either of you? You think that case goes away, or will it continue litigating?
I sincerely hope that the Office of General Counsel and the new commission take a hard look at whether or not they want to defend that litigation in the Fifth Circuit, because it implicates a lot of the issues that we've been discussing here today.
Right.
Yeah, I hope they take a look at it. I will say, from kind of the realism perspective, it's always difficult for an agency to walk away from a litigation that would inherently curb its authorities, even if that SEC is a little bit more skeptical of the authorities. I'm hopeful they'll take a good look. I don't think that we're going to get some sort of capitulation by the SEC that they're currently violating the Constitution in 4 different ways.
Right.
So it'll be interesting to see how that plays out, particularly under the guise that, I say, we haven't talked about it, but in connection with kind of the steps that the SEC has been taking already, Chairman Atkins has kind of required the SEC to do a review of the Consolidated Audit Trail and to come in and think about, are they doing what they should be doing here? Remains to be seen where exactly that falls, but there's obviously an interest in the SEC in reevaluating the entire process.
Right.
I don't know whether that's going to leave them on the NCLA litigation.
Right. Well, and maybe the 11th Circuit opinion, by laying out this framework for challenging the rulemaking, maybe that'll open up an avenue for someone else to challenge some other aspect of the various rulemakings that have created the Consolidated Audit Trail.
It's another notch in the Gensler loss belt in terms of the SEC's arbitrary and capricious findings against it over the course of the past 4 years. It does not look good for the agency.
Yeah, the circuit level case law that has come out of the Gensler era rulemaking has not been positive on the whole. Well, Chris, maybe we should check back in with you after a few months to see what the SEC does with this ruling and the funding mechanism for CAT. But in the meantime, congratulations on the win, and we'll keep an eye on that other case. And Jennifer, thank you for joining today's episode. Thank you both. Everybody else, if you want to know more about ICAN, go to icanlaw.org, and we'll see you on the next SEC Roundup.